Welcome everyone to the fifth webinar in our HPOA webinar series. Today we're talking about the legal framework for human rights obligations under the HPOA. I'm Diane Millett, I'm the registrar of the college, and today I am in the Okanagan Valley, so I'm calling in from the ancestral lands of the Okanagan Silks people, and very privileged to be able to work from time to time from these lands. It's my pleasure to introduce our two speakers for today. First, we have Angela Westmacott. Angela is a lawyer who has worked for 30 plus years in the field of regulation and other areas of law. Angela has been longtime general counsel to many of our legacy colleges and provides general counsel services to the current CHCPBC. So we're delighted to have Angie with us today. She's very knowledgeable about the legal framework. She and a colleague wrote a discrimination primer for the colleges that has been very helpful in assisting us to understand what our obligations are as a regulator under the HPOA as it relates to discrimination. So Angie is certainly the expert in this topic. And then Angie is going to be followed by Len Pierre. Len is the principal and founder of Len Pierre Consulting. He is an Indigenous consultant and educator, and Len has also done a lot of work with the legacy colleges and also with CHCPBC to help support our learning journey around reconciliation and what we need to do to meet the obligations also under the HPOA. So we're delighted to have Len with us today as well. So with that, I'm going to, I think, hand it over to Angie to get the discussion started.
Thank you, Diane, for that introduction on behalf of both Len and myself. We're very delighted to be here to talk about these important topics. Just by way of present introduction, we will be covering off, as I said, the legal framework for human rights, and that will cover off the concept of discrimination and the concept of anti-discrimination measures as contemplated by the Health Professions and Occupations Act, the specific human rights obligations imposed on licensed health professionals, I'll refer to as licensees, under the HPOA. And then Len will take over and really be addressing the topic of understanding anti-Indigenous discrimination and all the forms that that can take. So I see my role very much as laying out the legal framework for all of the obligations under the HPOA, which will require some consideration of the Human Rights Code as well. But Len will really be putting the meat on the bones and fleshing out all of those issues from an Indigenous perspective. We want this to be less formal. We see our role as being there to assist you in guiding you in this journey towards meeting the obligations under the HPOA. This is new legislation, it's complex legislation, and we want to do whatever we can to support both colleges and licensees to meet the spirit and requirements of that legislation. So when the HPOA comes fully into force in the spring, all of you will become licensees under that legislation rather than registrants. The HPOA will certainly be introducing significant changes to the regulatory framework for colleges, giving the registrar and the various committees, such as the new investigation committee, which will replace the inquiry committee, and the new license committee, which will replace the registration committee, far more powers and responsibilities. But it will also introduce some significant changes for you as licensees. As professionals delivering healthcare services to the public, whether you're in the public sector or in the private sector, it's important to recognize you have always been subject to the obligations under the Human Rights Code, which is separate legislation, which prohibits certain forms of discrimination. And I should say that the Human Rights Code applies across the board to individuals, organizations, everyone in the public sector, everyone in the private sector, whether you can be a government ministry named in a human rights complaint, or you could be running a corner store. So it has very broad application. The obligation to comply with the Human Rights Code is really just to refrain from engaging in discrimination. And not discriminating has always been a practice standard for professionals. Whether you're a lawyer, a doctor, or an occupational therapist or a psychologist, you as a matter of professional practice, have to refrain from discrimination. Most colleges now have that codified in a written standard of practice or in a code of ethics, but even if it's not, it's something that all professionals have always had to be conscious of. But more often than not, where there were complaints of discrimination raised against professionals, they generally were filed with the Human Rights Tribunal. It wasn't often that people would bring forward complaints of discrimination with colleges that regulate their health professionals. And I think that may change. What the HPOA does is bring into sharper focus the obligation not to discriminate as defined within the Human Rights Code by expressly making discrimination an act of professional misconduct. But it goes further. It imposes a positive obligation on you as licensees and on colleges to proactively take what are called anti-discrimination measures. And what that means will be in part the focus of my part of the presentation. I'm sure Len will address that as well. So the HPOA differs from the current Health Professions Act in three key ways insofar as human rights are concerned. It takes far different approaches to other matters as well, but the focus of this is on human rights. So in relation to human rights obligations, and in contrast to the Health Professions Act, the HPOA does three things differently. First, it expressly, and when I say expressly, I mean there's language in the Act which actually says this, prohibits licensees from engaging in discrimination as defined in the Human Rights Code. And I will explain what that means momentarily. Secondly, it expressly makes discrimination an act of misconduct, or as we think of professional misconduct, which means that an allegation of discrimination can be the subject of a complaint which will be investigated by the college's investigation committee under the HPOA and may, if substantiated, lead to regulatory consequences or a discipline hearing if there's a direction to issue a citation to address the alleged misconduct. Thirdly, the HPOA requires licensees to take proactive measures to fulfill anti-discrimination objectives. And I pause there to note that I will unpack each of those concepts in the slides which follow, but I also want to flag for you that none of this is in the current Health Professions Act. These are all obligations that are now set out in the Health Professions and Occupations Act. And we're all at the front end of this process learning what some of that will mean and how to operationalize it. Understanding the concept of discrimination under the Human Rights Code provides, I say, a useful starting point. I think it's a necessary starting point for understanding the human rights obligations under the HPOA. So the code prohibits discrimination on certain protected grounds, which I'll explain, in the context of certain areas of activity, which I'll explain. But importantly, it does not require individuals or organizations to promote equality or to take anti-discrimination measures. If you look at the Human Rights Code, there's a purpose provision at the front end which contains very broad statements about equality and promoting inclusivity. But at the end of the day, the code itself does not require members of the public, individuals or organizations to take positive steps to promote equality. It only prohibits discrimination in delineated areas on delineated grounds. So the term discrimination is not helpfully defined in the code. If you look at Section 1 of the Human Rights Code, the term discrimination refers to contraventions of other sections of the code, so that's singularly unhelpful. So what human rights tribunals across the country, they all have similar, administer similar legislation, what they look to are how the courts have interpreted discrimination, and they've adopted that definition for human rights purposes. So in a case, it's a seminal case from 1989 from the Supreme Court of Canada, which arose in a professional regulation context called Andrews and the Law Society of British Columbia. It was one of the first cases which the Supreme Court of Canada was grappling with. What does discrimination mean under the equality provisions of Section 15 of the Charter? And Section 15 of the Charter protects equality before and under the law for all of us in this country. And Mr. Andrews was a British citizen who completed all the requirements to be called to the bar in British Columbia, except he wasn't a Canadian citizen, and Canadian citizenship was one of the requirements to be called to the bar at that time. So he brought a constitutional challenge, which went all the way up to the Supreme Court of Canada and was successful. And the court found that it was discriminatory for the Law Society of British Columbia to impose a Canadian citizenship requirement when it wasn't necessary to show that someone was qualified to practice law. Excuse me. And so what the Supreme Court of Canada said was that discrimination may be described as a distinction, whether intentional or not, but based on grounds relating to personal characteristics of the individual or group, which has the effect of imposing burdens, obligations, or disadvantages on such individual or group not imposed upon others, or which withholds or limits access to opportunities, benefits, and advantages available to other members of society. There's two takeaways from that definition, which probably sounds a bit opaque, so let me try and put that in plain language. We all discriminate. Governments discriminate all the time. Young men under the age of 25 pay higher insurance rates for automobile insurance than the rest of us. People have age limits for over 55 condos. There's all types of discrimination out there. But what this definition focuses on is discrimination which is based on any of the protected grounds or analogous grounds under Section 15 of the Charter, which are very similar to the grounds that are listed in the Human Rights Code. And the two important takeaways are that there's no need to have an intention to discriminate. Actions can be very well intentioned, but if they're discriminatory in their effect, that is enough to constitute discrimination. If you're faced with a complaint of discrimination, you say, well, I didn't intend to cause someone hurt their feelings. That's not going to be a defense. What was the impact of a person's actions or conduct, and did that impact have a discriminatory effect? The second takeaway is that discrimination is a broad term in the sense that it can relate to imposing burdens or obligations or disadvantages on an individual or group based on protected grounds, but it can also take the form of denying or limiting access to opportunities or denying benefits or advantages that are available to other members of society. So that covers a very potentially broad area. Are your actions. So it is an employer who intends to fire someone and the employee says, well, you have to accommodate me. I have a mental disability. Firing someone would clearly be imposing a disadvantage on a person, and it would have a linkage to a protected ground. And that's why those areas of employment law can be a minefield to cover. But the two takeaways from this slide is you don't have to have an intention to discriminate. It's the effect of the conduct, and that discrimination covers both imposing disadvantages on people, but also denying opportunities or denying benefits. So, what are these protected grounds under the Human Rights Code? So, the protected grounds cover Indigenous identity, race, color, ancestry, place of origin, religion, marital status, family status, physical or mental disability, sex, sexual orientation, gender identity or gender expression, and age. In relation to employers and occupational associations, and the college is an occupational association, the protected grounds also include political belief and criminal or conviction of a criminal or summary conviction offense, which is unrelated to the employment or unrelated to membership or proposed employment or membership in the association. So, for example, if the college receives an application for registration from a person who has a criminal conviction, they would have to look at a number of factors, including when did the criminal conduct occur, what were the circumstances of the conduct, does the conviction for the conduct relate to the safety of the public? Is it a risk to allow a person with this type of conviction to practice the profession? So it's a very contextual inquiry to determine how old was the person at the time. Is it something that happened when they were a teenager 40 years ago? What was the nature of the criminal conduct itself? Was it shoplifting or did it involve harming somebody? And is there a direct nexus between the criminal conduct and the occupation or profession that the person wants to pursue? So those are the protected grounds, but I've also talked about the areas of activity that are regulated by the code. It's not that you can't discriminate on protected grounds writ large. It has to be, you can't discriminate on protected grounds in relation to certain areas of activity. And those areas of activity are publications. So when you're publishing statements, Section 7 of the code, in relation to accommodations, services, or facilities customarily available to the public under Section 8. I'm going to come back to that. In relation to the purchase or tenancy of property under Sections 9 to 10 of the Human Rights Code. In relation to employment and wages under Sections 11 to 13 of the Code. And in relation to membership and treatment in unions, employer organizations, and occupational associations, Section 14. And the takeaway point from this slide is that when you are providing professional healthcare services to patients or clients, that would be considered a service customarily available to the public within the meaning of Section 8 of the Human Rights Code. And then, therefore, you cannot discriminate when you provide those services. Similarly, when the college is processing applications for registration under the Health Professions Act or for licensure under the HPOA, they cannot discriminate because they're in an occupational association under Section 14 of the code. So I just want to provide you with some context about the human rights process. Anyone can file a human rights complaint with the BC Human Rights Tribunal. You can fill out a form online. There's no cost. It's very easy to do. Whether the mere act of filing a complaint does not mean there's been a violation of the Human Rights Code or that discrimination has occurred. Whether the complaint is substantiated can only be determined in a human rights hearing. So it's much the same as filing action or initiating civil litigation against someone. It starts the process, but ultimately down the road, there has to be a trial to determine whether the plaintiff has a claim. So as I said, there's no cost. Once a complaint is filed, the person who's named in the complaint or the organization named in the complaint has to file a written response, and they have the opportunity to bring an application to have all or part of a complaint dismissed under certain grounds under the Human Rights Code, and that's commonly done. But if there's no application to dismiss the complaint, which is a written process, then the complaint will have to proceed to a human rights hearing. And at a human rights hearing, the complainant, the person who filed the complaint, has to establish what's called a prima facie case of discrimination. And to do that, they have to do three things. They have to show that there was some sort of adverse impact to them, whether they were subjected to a burden or a disadvantage or denied a benefit or an opportunity or access to something. They have to show some sort of adverse impact to them. Secondly, they have to show there's a nexus or some type of connection between that adverse impact and one of the protected grounds under the code, the race, sex, disability, gender expression, sexual orientation, whatever it is. And sometimes complaints allege more than one of the protected grounds. This second branch of the test is not a difficult hurdle for a complainant to meet because they don't have to show that the protected ground was the only cause of the adverse impact. It only has to be one of many causes. As long as it's one of the causes, that will suffice to establish a prima facie case of discrimination. Finally, the complainant has to show that the adverse impact they experienced occurred in the context of an area regulated by the code. So was it a publication? Was it in an employment context? Was it in residential tenancy? Was it in membership in a professional association? So they have to identify whether it was a regulated activity under the code. Once a complainant establishes a prima facie case of discrimination, showing those three things, an adverse impact on them, a nexus, some even not a main nexus, but some connection between the adverse impact and a protected ground, and that the conduct took place within one of the regulated areas of activity under the code, the burden shifts to the person or organization which is named in the human rights complaint, and they are referred to as the respondent to a human rights complaint. And though the person or organization named in the complaint can still justify their action by showing that they acted in good faith to serve a legitimate purpose and that their actions were reasonably justified, that if the complainant required accommodation, that they accommodated the complainant to the point of undue hardship. It's beyond the scope of this presentation to get into the huge area of law about what constitutes undue hardship, but suffice it to say that you have to be able to demonstrate that your actions were reasonable and you considered all possible alternatives that you could reasonably do without injuring undue hardship in your business. So I'm explaining discrimination under the Human Rights Code because that concept has been directly incorporated into the HPOA. We call it in legal terms incorporating it by reference. So under Section 9 of the HPOA, discrimination means conduct prohibited under the Human Rights Code, which relates to the following areas. I've summarized them here, but it tracks pretty closely. A, the provision of health services while practicing. So if you, so there's no question that the HPOA applies directly to prohibit discrimination while you're providing health services to patients or clients. B, to any interactions with patients or clients and interactions with the college. So even in your interactions with the college, you have to be careful about not discriminating. C, your employment relationship with your staff. I'm going to come back to that. And D, the use of one's status as a licensee in relation to publishing statements. Employment relationship with staff. I have to say, and I have worked with colleges and advised them for many years, and that isn't an area that colleges have typically inserted themselves into. They see that more as a business thing, a contractual relationship, or a matter more for the Human Rights Tribunal to deal with, or courts through wrongful dismissal claims. If there's an aspect of a registrant's conduct that, is abusive or harassing, then yes, that would violate the code of ethics. But it's purely as a business relationship that has not been a focus for the work of colleges in the main. But the HPOA makes it clear that licensees, as employers, will have to ensure they do not discriminate in relation to their relationship with their staff in their hiring processes, in how they oversee their staff, the policies they have in place for dealing with their staff, dismissal of staff. So it is possible that if you're dealing with a challenging staff member and you're trying to get rid of them, one of their options may now be, in addition to filing a human rights complaint, to file a complaint with the college. The HPO makes it clear that colleges have authority over this area of your practice. The use of one's status as a licensee in relation to publishing statements, I just want to say that all of us have a guaranteed right to freedom of expression under Section 2B of the Charter, but it's not an absolute right. And there is a plethora of case law from courts talking about the limits that colleges can place on speech by regulated professionals. Two examples. If any of you have followed the Amy Ham case, the BC College of Nurses and Midwives took Amy Ham to a discipline hearing in relation to statements which she had published online, which they said were derogatory and discriminatory to transgender persons. The panel of the discipline committee upheld that complaint, and it's now being appealed to BC Supreme Court. I'm sure that case will go up higher. Another example of using one's status in relation to publishing statements is Jordan Peterson from Ontario and his ongoing dispute with the College of Psychologists of Ontario. Again, he was making statements which were considered discriminatory, I believe calling a city councillor who was non-binary a thing, and things and statements of that nature, misgendering people. So when you're publishing statements, just be careful that if you're identifying yourself as a licensed professional, that may bring it within that will bring it within the purview of the college's regulatory purview. Amy Ham would not have had a problem if she had just published her statements but didn't identify herself as a registered nurse when she did so. It was the fact she identified as a registered nurse in her publications that was a problem from a professional misconduct point of view. So I want to speak about the guiding principles that are set out for colleges under the HPOA, because I think that also provides context for the anti-discrimination measures, which both colleges and licensees have to take. So Section 14 of the HPOA sets out what are called guiding principles, which require colleges to do three things: to protect the public from harm and discrimination, to take and promote anti-discrimination measures, and to support and promote awareness of reconciliation with Indigenous peoples, the UN Declaration on the Rights of Indigenous Peoples, and the need to address racism and anti-racism specific to Indigenous peoples. I take C to also incorporate DRIPA as well, our provincial legislation. These guiding principles are a message from the legislature that these are the core values which regulators must use when they're exercising their power to regulate licensees under the HPOA. So put another way, these guiding principles are the lens through which the college decision makers, whether it's the registrar, the investigation committee, the license committee, the quality assurance committee, these guiding principles are the lens through which they have to exercise their powers. I'm going to be coming back to this, but licensees also have some of these obligations. They have the obligation under Section 72 to protect the public from harm and discrimination. Licensees have the obligation to take, but not promote, to take anti-discrimination measures. And more on that momentarily. So the guiding principles talk about the obligation of colleges to take and promote anti-discrimination measures. The Section 1 of the HPOA defines anti-discrimination measures as the measures taken, including implementing processes for the purposes of conducting regulatory processes or providing health services in a manner that is consistent with one or more of the objectives referred to in Section 15. Section 15 I'll get to in a moment. I just want to say that anti-discrimination is really a term that encompasses the obligation to proactively identify, prevent, and eliminate discriminatory ideologies, and proactively acting to create environments of greater inclusivity, equality, and justice. So when we're talking about anti-discrimination measures, for me, that's what anti-discrimination measures mean. So as licensees, you will be required under Section 72, Sub 1 of the HPOA to take anti-discrimination measures. The HPOA doesn't provide guidance on what measures you have to do. It doesn't say, well, you'd have to do X, Y, and Z. It would be helpful if it did, but it doesn't. Instead, what it does is set out the objectives, both general and specific objectives of anti-discrimination measures, which mean the objectives are to foster physically, culturally, socially, emotionally, and spiritually safe practices, to adopt anti-racism approaches and tools to support those approaches, to treat patients respectfully in relation to providing health services, to facilitate meaningful communication with patients and encourage their participation in decisions that affect them, and to meet other prescribed objectives. And just whenever you see the word prescribed in the HPOA, it means that the legislature has reserved the ability for cabinet or a cabinet minister, the Minister of Health, to set out other things by regulation. So I'm sure it's sounding vague, anti-discrimination measures for those of you that aren't steeped in human rights processes, but let me try and distill it down. In my view, anti-discrimination measures involve steps such as education, both formal, informal, self-directed, and self-reflection to ensure that one meets the objectives of practicing in a safe manner. And that goes back to the language of Section 15, to practice in a safe, physically, culturally, socially, emotionally, and spiritually safe manner. Secondly, I think it involves adopting and implementing policies and practices that reflect anti-racism approaches. If you practice in a public setting for a health authority or another public body, there will be policies and practices in place that address all of this that you have to be familiar with and that you have to comply with. But if you're in the private sector, in your own practice or an embedded practice or some other arrangement, you either have to ensure you have your own policies or that there are policies in place that apply to your practice that address anti-racism, that address anti-harassment, that address some of these obligations. And it also means having an anti-discrimination measure means that when you observe others who are acting in a discriminatory or specifically racist manner, you take action and you support patients, clients, colleagues, and others who have experienced racism or other forms of discrimination. I will say that this is very early days. The introduction of anti-discrimination measures into professional regulation legislation is new. And I think it will take some time for colleges to provide guidance, for professional associations to provide more guidance. But in the meantime, I think if you focus on sort of education, on self-reflection, looking at your policies, and just generally being more alive to what's happening around me. Are there things that I should be concerned about and acting on? I think that is giving effect to anti-discrimination measures as contemplated by the HPOA. So, to recap, the specific obligations on licensees under the HPOA are summarized on the next few slides. As a licensee, you will have a duty not to discriminate when providing healthcare services in your employment relationship with your staff and when publishing statements in which you identify your professional status. If you're just writing letters to the editor and not identifying yourself as a registrant of the College of Health and Care, that's one thing. But if you're writing letters to the editor or publishing online statements in which you're saying, making comments and linking them or identifying yourself as a licensed professional, that will bring those statements within the college's regulatory purview in the event of a complaint. As I said at the outset, all professionals have always had the obligation to comply with the Human Rights Code, which means not discriminating when you're providing services to the public. But it is being brought into sharp focus under the HPOA. And while it doesn't change your obligations, I think what it does do is it serves an educational role to members of the public who are going to be aware that they can, going forward, not only file complaints with the Human Rights Tribunal, but they can also file complaints of discrimination with the college as well. Under Section 11.1 of the HPOA, discrimination is an act of misconduct which can lead to regulatory sanctions. So if someone comes forward with a complaint of discrimination against a licensee, there'll be an obligation on the part of the registrar to refer it for investigation and for the investigation committee to determine provisionally, is there a basis for this complaint? And if so, to determine what the appropriate regulatory outcome is. In addition to not discriminating, which you've always had that obligation as a professional, you will have a positive obligation under 72.1 of the HPOA to protect the public from harm and discrimination. And this notion of protecting the public from harm and discrimination means not only not discriminating, it means proactively taking action if you observe discrimination by others, but also to take anti-discrimination measures, which I've just talked about, education, self-reflection, ensuring you have appropriate policies in place, things of that nature. Under the HPOA, there are numerous provisions which require colleges to make bylaws on certain topics. And one of the areas they have to make bylaws is in relation to anti-discrimination measures. And the college has, of course, done that in their draft bylaws. And they also have standards of practice like the Indigenous Cultural Safety, Humility, and Anti-Racism Standard, which you'll have to be very familiar with and comply with. Another change in the HPOA is the introduction of the duty to report, where you have reasonable grounds to believe that another licensee has engaged in discrimination. I'll finish on this slide and just make a couple of more practical points. I think I've already noted that where a patient or a member of the public that you've interacted with or an employee perceives that they have been discriminated against by you, they can file a complaint with the college and a complaint with the Human Rights Tribunal. So it's possible to have parallel proceedings, one before the college and one before the tribunal. In terms of what I would say to licensees going forward under the new HPOA, I mean, you know the importance of clinical record keeping, but going forward, if you have an encounter with a patient, a client, a member of the public in the context of your professional practice, two things. There's nothing wrong with apologizing. It's not an admission of liability. If someone's feelings have been hurt, you can apologize. That's not an admission that you've done anything wrong under the Apology Act. It's perfectly appropriate and something I would always encourage people to do, but also document what's happened. I cannot stress enough that when there's a dispute between parties as to what was said or what occurred, and the matter goes before any type of decision maker, whether it's the BC Human Rights Tribunal, a court, a college complaint investigation committee, or a college the discipline committee. The decision maker will place heavy reliance on notes that were taken contemporaneously at the time before any complaint was filed. So one of the best things you can do is document carefully what has happened. Um, reach out to the college, reach out to your professional associations, and actively look for more training, more education. There's some great resources online and elsewhere that will assist you in trying to unpack and operationalize the obligation to take anti-discrimination measures. And most of all, focus on your communication. In all the years that I've worked with colleges and helped with countless complaints, 99% of those complaints stem from communication issues. So being more careful about how you communicate with your patients, with your clients, with your staff, with everyone, because frankly, that is the best insurance that you have in terms of mitigating the risk of a human rights complaint. And with that, I'm going to turn it over to Len.
Hi, Shika. Thank you so much, Angie. And I just want to begin by, echoing and regurgitating Angie's earlier comments that really I want to hold this space. I only have 5 slides to share with you. Angie has kind of, at a very high level presented the legal framework. And then now, as Angie passes me the baton, I see my role as bringing this to a very micro conversation on Indigenous experiences with full honor and recognition under the HPOA guiding principles for the United Nations Declaration on the Rights of Indigenous Peoples, advancing truth and reconciliation, and of course, really honoring Indigenous cultural safety and humility within healthcare. So when I present on Indigenous specific anti-discrimination and anti-racism, there are two really key pieces of understandings that really situate and position Indigenous people's experiences of racism and discrimination in this country and sets us miles apart from other experiences of discrimination. And Angie's already mentioned this, that, we have discrimination against gender, people who, people with who are trans experience discrimination, newcomers and immigrants to the country, women experience discrimination in professional workplaces, and of course, other people of color experience discrimination in Canada today. But what makes discrimination against Indigenous peoples, First Nations, Métis, and Inuit people in colonial Canada so unique is just how ancient and deeply entrenched colonial ideology and colonial socialization plays into our professional workplaces today. So I wanted to offer these two terms that I feel like every professional who works with human beings for a living should have in their anti-discrimination tool belt. And that first definition is colonial socialization. And I'm going to give you some examples of that on the next slide. But by definition, and this is LPC, Len Pierre's definition of colonial socialization, refers to Canadian intergenerational processes through which individuals, institutions, and societies are conditioned, often unconsciously, to adopt, normalize, and reproduce colonial values, beliefs, behaviors, and power structures. And we usually define it as common sense, or we back it up with neutrality or what we perceive as the everyday normal. That is colonial socialization. And it is ultimately what gives way to anti-Indigenous discrimination today. Often without intention, often, without any sense of providing harm, but it's usually backed by our colonial policies and standards. So if you are new into creating your anti-discrimination, policies for your site, your clinic, your practice, this is a really good opportunity to examine how colonial our policies are at the end of the day. And the second definition I feel like we should all have to understand Indigenous experiences that are unique from other experiences of discrimination in this country is understanding colonial ideology. By definition, colonial ideology embeds into our thinking, relationships, decision-making practices, and systems, shaping how we understand authority, knowledge, leadership, success, professionalism, land, and Indigenous peoples. This is ultimately the foundation that gives way for such widespread anti-Indigenous racism and discrimination today. And I wanted to share that with you because there is a very common misconception that when it comes to Indigenous cultural safety, reconciliation, and anti-discrimination, many professionals think it's just about being kind or respectful to Indigenous peoples. And I'm like, no, you should already be kind and respectful to all of your customers and clients and patients that we work with. Real reconciliation and cultural safety and anti-discrimination is about systemic change and transformation. Nowhere in the Truth and Reconciliation calls to action does it say you need to have an Indigenous patient to engage in reconciliation. Nowhere in the BC United Nations Declaration on the Rights of Indigenous Peoples does it say you need to have Indigenous patients or clients to engage and get behind UNDRIP. So this work is ultimately about systemic change and transformation. But therein, I will pause and share with all of our colleagues on the line here that this is a really monumental moment to have indigeneity and Indigenous experiences included in the HPOA, to be included in the college and all of the other colleges across the country, because it's never been done before in the history of this country, which is an act of reconciliation in itself. So to give you a sense of, what type of bias we have been exposed to with colonial socialization and ideology, on the left side of the screen here, these are just a few examples of anti-Indigenous socialization that we have been exposed to some degree on the planet. These are not Canadian specific examples. These are not American or Western specific examples. I teach at an international college with students from across the planet, and I teach them about colonial socialization. And whether you grew up in the Philippines, Japan, Russia, Ukraine, India, we have all been exposed to some type of anti-Indigenous narrative. Pocahontas, sports mascots, the children's game Cowboys and Indians, where the cowboys are the good guys, Indians are the bad guys, the news and the media, pulp culture for several decades, in fact, over a century on the planet, colonial socialization has been pumping out to the population this anti-Indigenous narrative. And that narrative will inherently contribute to our unconscious bias. Now, we know through psychology today that 90% of our biases are implicit, meaning we're completely unaware of how we're judging other genders, other races, other ages, and other abilities in our day-to-day work. That 10% of biases that we are familiar with, when we say things like, this is my best friend, this is my work wife, this is my work husband, that only makes up 10% of our biases that we are aware of. This is why cultural humility and what Angie was saying before with self-reflection goes such a long way, because we don't know what we know and how we're treating people differently. Colonial ideology, on the other hand, is what scaffolds the country of Canada today. Canada is built on a firm foundation that is colonial ideology. Colonial ideology is the idea that ultimately, to simplify it, is the idea that Indigenous peoples are less deserving, less worthy people. It sounds harsh, I know, it sounds brash, but it's ultimately what gives birth to colonial countries across the planet today. Canada would not exist as a country, if early colonizers and settlers came into our lands and territories and said, you know what? We just need to respect the human rights and the human dignity of these local Indigenous peoples. Canada never would have been born with that mentality. Canada exists as a country because of the idea that we are less deserving, less worthy people. So it's only natural and innate that every system that now scaffolds our country, education, healthcare, justice, social services, will scaffold and uphold some elements of colonial ideology as well. And this is ultimately where marginalization comes from. Usually, discrimination is experienced by marginalized communities, people of color, trans people, people who identify as gay, lesbian, trans, queer, bisexual, two-spirit, non-binary, non-conforming, women, people who identify as women, people with disabilities or neurodivergence, people of color, or what I like to call the global majority, are all on the receiving end of many aspects and manifestations of discrimination in our Canadian systems today. And we have discrimination and we have marginalization because we exist in a colonial country. And this is why I feel like we need to be aware of and have those definitions in our professional tool belt so we understand the root source, the root cause of this problem. When it comes to the relationship of, it's not all for naught. Why am I talking about colonial ideology? Why am I talking about colonial socialization? There is a pathway to harm. This is and this was very largely reflected in the In Plain Sight report that came out in 2019, 2020. Widespread manifestations of discrimination against Indigenous peoples and Indigenous, holy words are hard. I'm fasting today. I'm about 20 hours into a fast. Indigenous specific experiences of racism. And it all stems from colonial socialization. Unaddressed colonial socialization will give way to stereotypes. And by definition, stereotypes are just these oversimplified, generalized, often wildly inaccurate ideas about Indigenous peoples. So I know you've heard many myths out there as us Indigenous peoples. The myth that we don't pay taxes. Whew, we pay taxes. The myth that we all get a free education. That's false. It's incorrect. Misinformation or disinformation. The myth that we have a genetic predisposition towards addiction or alcohol, when at the end of the day, Indigenous peoples have the highest rates of abstinence compared to any other racial or ethnic group in this country. I think it's largely to combat that myth. Unaddressed stereotypes and myths about Indigenous peoples will give way to prejudice. Now, I do want to pause and really distinct the difference between prejudice and discrimination. In my professional practice, I work with so many different professionals that use prejudice and discrimination interchangeably, and they are not the same things. Prejudice, by definition, are internalized judgments we have about other people's cultures, other people's gender, other people's age, other people's abilities. So they're internalized. What I will say about prejudice is it's not a bad thing. There's nothing wrong with having prejudice. And in Canada, in the Western world, we often associate prejudice within this good-bad binary. Prejudice is bad, and you're not a bad worker, you're not a bad professional, so how can you have prejudice? We're really failing to hold ourselves accountable with the firm fact that prejudice is natural, prejudice is innate, it is inside every single human being that we work with, and it is 100% impossible to be without prejudice. Why? Because we're only born into one framework, one cultural framework. And you are raised in that framework. And when you meet people from a different cultural framework from you, it's very natural when you have judgments about that person's culture. That's prejudice. Where prejudice becomes harmful is unaddressed prejudice will give way to discrimination. Prejudice is internal, discrimination is external. It's where we treat people differently because of our prejudiced beliefs about people. And that's where the real harm comes from. So there was a question that came out in the pre-questions that were sent out to the entire audience. And I wanted to bring that question into this slide. And that question was, how is discrimination different from Indigenous specific racism? We have a practice standard on Indigenous racism. Is this more than what is required in that? And I would say yes and no. I would really look at these things not existing on their own, but very much related to one another. So while you have this emerging in the HPOA, we still have our cultural safety standard and anti-racism standard as well. They coincide, they go together. They are part of the same pieces of work. And those pieces of work are not an add-on. They're really our ability to enhance the work that we are already doing, the care and the well-being of the people that we take care of. What I will say is we have to check in with those prejudices, um, and move away from that good bad binary thinking about prejudice. So we shouldn't be asking ourselves if we are prejudiced. We really need to hardwire in this tool, this professional tool we can all do. It's simple, it's not easy. And that's training yourself to ask the question, how am I being prejudiced in the work that I am doing when I'm working with somebody who is a different skin color than me, a different cultural background than me, who speaks a different language than me, who prays to a different God than I pray to, if they pray to God at all. If you can train yourself to constantly check in, how are you being prejudiced? I promise you, it will transform the way you interact with your fellow human beings. And as Angie mentioned, it will put yourself into this zone of critical self reflection where you could be with your language, you could examine your behavioral interactions, and you can ask yourself, how can I be less colonial when interacting with this person? How can I be more inclusive, more diverse, or culturally safer when working with this person, this patient, this client? So I would say when it comes to our anti-racism cultural safety, it includes and encompasses anti-discrimination acts as well. And on the topic of anti-discrimination, we say this in social justice a lot, that in Canada, because of earlier slides, there's no such thing as being non-racist. There's no such thing as being non-discriminatory because it's so widespread in our fabric of Canadian society. We are either perpetuating racism and discrimination by being quiet, silent about it, or we're evoking anti-racism or we're evoking anti-discrimination into our professional practices, our policies, our procedures, and of course into our overall physical sites. The image that you see on the screen here, I'm not going to spend too much time here, but it is a tool that we share with many, many folks who work in the domain of healthcare. We call this the Indigenous Cultural Safety Spectrum. And we find it to be a very useful, pragmatic tool for examining behaviors when we are working with Indigenous community members, Indigenous clients, Indigenous patients. We often define cultural safety as a journey, not a destination, and it's practice, not perfection. If cultural safety is a journey for many of us, quite often that journey begins on the lower end of the spectrum here, when we're coming from this place of cultural avoidance. And cultural avoidance, and I'm not picking on any professional domains here in particular, I'm just sharing with you patterns that I've picked up in the last 10 years in my Indigenous consulting practice. There's a very common misconception around professionals in every sector that, being good and kind and respectful, that's anti-discrimination. That's anti-racism. That's cultural safety. And I'm like, well, if we're not leaning into, that racism and discrimination do exist and do manifest, we're not really, there's more gaps in our awareness. And then we're lacking the accountability as well. So cultural avoidance is one of those gaps. Cultural avoidance looks like where clinics, professionals, care providers, health providers might say things like, well, in my practice, I don't see color. I don't see culture. I just treat everybody the same. And because I've been doing this for 10 years, I'll look them in the face and I'm like, no, you don't. We don't treat everybody all the same. We are very social creatures at a very human level. We are hardwired for culture and we're hardwired for identification. We are not robots that can flip a switch, and all of a sudden we don't see color and we don't see color. And I think professionals mean very well when they say things like they don't see color, they don't see culture. I have a firm faith in humanity. We mean well, but it's actually very dangerous language at the end of the day, because if somebody's looking at me, if a healthcare provider's looking at me and I'm their client, I'm their patient, and they're telling me they don't see my color, they don't see my culture, what they're really telling me is they're refusing to see my reality. And you can't treat me safely, you can't treat me respectively, and you can't treat me with dignity if you are not taking all of that which I am into consideration when working with me. So I think we mean well when we say things like we don't see color and we don't see culture, but it's very dangerous language at the end of the day. So we want to progress out of cultural avoidance and really start talking about cultural awareness, cultural sensitivity, cultural safety, and advocacy. And the behaviors we want to avoid are under cultural avoidance, the superiority, apathy, dominating saviorism. These are largely a lot of the behaviors that we have documented through the In Plain Sight report back in 2020. And sometimes they are tolerated in different clinics, hospitals, different departments because of high stress, high urgency, high efficiency syndrome. That's why I call it some clinics, some sites, and some departments can be overly saturated in what I call the tyranny of efficiency. Rather, we want to aspire to the behaviors located under cultural advocacy. Cultural advocacy looks like really great allyship. It's where we as non-Indigenous peoples begin to advocate for anti-discrimination practices and policies. It's where we advocate for addressing anti-Indigenous specific racism and cultural safety within everything we do in the healthcare setting. And the behaviors we want to aspire towards are humbleness, humility, empowering clients and patients that show up, asking questions. And we're starting to get okay with our own vulnerability in these spaces and in these conversations. Okay, last slide, I promise, and then I'm going to zip it. So I want to leave the group here with my top 5 anti-discrimination tools and Indigenous cultural safety tools. These are the most applicable, accessible, and efficient tools I have seen practitioners use in their professional practice. And the first one is really coming to terms with cultural humility. And cultural humility in practice looks like where we are getting behind anti-discrimination. We're advocating for Indigenous cultural safety. We know that we're on a learning journey, but it's not going to be perfect. We adopt a lifelong learner mentality, always aspiring to learn more about Indigenous culture, more about Indigenous history, and more about how we might be inherently perpetuating colonial values or colonial ideology onto Indigenous peoples, unintentionally, but inherently passing on. And then we're open to that feedback and we're open to our own vulnerability to receive that feedback if we are overly perpetuating colonialism on Indigenous clients and patients. Tool number 2. And it's the most simple tool that we all have access to. It's simple, it's not easy because you have to build in your own accountability mechanism. And that tool is training yourself. And I think, Angie, you mentioned this earlier, training yourself to constantly examine and re-examine your own language and behavior, your own language and behavior. Whenever you're working with marginalized groups, and yes, specifically Indigenous patients, Indigenous clients, asking yourself after that engagement, was my language okay? Was my behavior okay? And socializing that among your entire clinical team. So if you have a front desk clerk, encouraging them and coaching them to really examine and re-examine their own language and behavior as well when working with marginalized groups. I am very worried about people that think or assume. What do they say about the word assume? You know what I'm talking about. When people assume that their language and behavior and their clinical site is 100% safe for everybody. I'm like, come back here. We need some more humility training. And when we assume that our language and behavior is 100% okay with every patient, client who comes from marginalized, targeted, oppressed groups, it's actually where the most harm happens. And when we don't have that vulnerability to be able to open ourselves to feedback, we're not going to know how we might be inherently perpetuating harm against marginalized groups. What I will say about language and behavior is that sometimes our team, Len Peer Consulting, sometimes we're brought in to help investigate organizations that have experienced encounters of racism or discrimination at a staff level. So this is a staff who works in the organization that has, looking for some support in conflict resolution in the workplace. And 60 to 70% of the time, the harm that had happened was totally unintended harm. So what that means is the staff member internally in the organization who said something or behaved in a way that was harmful, 60 to 70% of the time, it was unintended harm, which is good news in my books because that means we can work on reflecting on our own language and behavior and how we show up to support people. I don't believe we roll out of bed as professionals, looking to pick a fight or oppress groups, especially for the work that we all signed up for here in this call. So that helps me sleep at night. That most of the time it's unintended. So that critical self-reflection on our own language and behavior is the magical zone we all want to be in. Number three, you are probably all very familiar with trauma-informed practice, for occupational therapists, physical therapists, psychologists, speech language. I think that we have new literacy and awareness around what it means to be trauma-informed. My argument is, and this is just my perspective, is that it is not enough to just be trauma-informed. We need to be able to do something with that information. We need to also apply equity-informed practice as well. Not equality-informed practice, equity-informed practice, which is given more time and attention where time and attention is due. And this is why Indigenous peoples who are deserving of more time and more attention is reflected in the HPOA with the guiding principle for reconciliation, cultural safety. We know that because of the long legacy of colonialism and colonial violence against Indigenous peoples. But not only do we need to be equity informed, I also believe that we need to be dignity informed as well, which is just honoring the human rights, the human sovereignty, and the human agency of the humans that we are working with. Number four, this is a really great tool to add to your professional tool belt if you have your own private practice, if you are a leader in your department or site or department, is to help instill a feedback culture in your site. When we have a great feedback culture, we are open to conversation, we're open to dialogue, so that I can hold my coworkers accountable. I can hold my colleagues accountable. That's also psychological safety. If I'm working alongside another practitioner and I see some totally unintentional harm or discrimination against another marginalized group or an Indigenous client or patient, I would hope I would feel comfortable and safe enough in my role and responsibility and my job security to go and offer that person some feedback without fear of repercussions or backlash. So creating a culture of feedback is one of the greatest ways that promote team growth, team capacity, and team accountability. I have no research or evidence to prove this, but I'm highly convinced the best performing teams on the planet probably have a really great feedback culture about them. Sports teams, political teams, United States Marines, you name it. I highly sense the best performing teams have a great feedback culture about us, about them. So we need that feedback culture to talk about discrimination and prejudice and racism. And lastly, the fifth tool I will share with you is just promoting a culture of learning. And Angie's already spoken to this, is like the zone of transformation is when we endorse, adopt, and advocate for continuous learning, for lifelong learning and lifelong unlearning as well. Because we don't know what we've picked up in our past through colonial socialization that we might need to retire eventually in our professional practice. Okay, I promised you that was it. That's it for my big talking head. So I'm going to pause here and hand the floor back over.
Thanks so much, Angie and Len, for those presentations. There's a lot to digest in what both of you just shared with us. So I think I'm glad this webinar is recorded. I think we'll have to go back and watch it again. But Angie, one of your comments was around, the time, the early days and the time it's going to take all of us to really understand what this means for us as a college and also for licensees and for members of the public. So I do think we need to remind ourselves that this is new for all of us, and it will take time to actually apply the principles and understand what they mean in our regulatory work and in the delivery of health services.
Yeah, absolutely. I mean, the college is on the vanguard here. There's no other legislation that does this, and no other regulator across Canada that has these obligations. So you really are going to be on the leading edge of this, and it will take time. Yeah.
Yeah, thanks. I know Michelle handles the questions that were sent in advance, and so I'm going to ask her in a moment if there are any. If others have questions, please pop them into the question and answer um, box there. But Len, I actually have a question for you. I know you have a lot of resources on your website. Do you have any that are specific to anti-racism, anti-discrimination, and anything that we could maybe point the audience to that would be available to them?
Yeah, absolutely. I would definitely say that all of our resources on our website are rooted in closing the gap in Indigenous relations in colonial Canada. So they all, to some degree, have resources and awareness and tools to help professionals be more culturally safer when working with Indigenous peoples. But one that comes off the top of my mind is definitely our Indigenous Trauma and Equity Informed Practice communication guide. So we have a how-to guide when you're working with Indigenous patients or clients or community members who come into your physical site. We have a communications guide, and this is a really great guide for any of your staff who are working, interfacing with the broader public. Things to say that are trauma informed, and some things definitely not to say and behaviors to abide by too, that is really rooted in a trauma informed practice. Another one I might offer is if you're looking to transform your physical site. So if you have an exam room, if you have a lobby entrance or a waiting room for the public in your professional practice, and you want to transform that to, because if let's say you have a very significant portion of the population or your clientele are Indigenous, and you want to transform your physical site, we have another resource called Opening Space for Resurgence, which talks about how you can embed territorial acknowledgements, purchase local Indigenous artwork without appropriating that artwork, contract local artists to come in and help transform your physical space so that it is more culture relevant and appealing to Indigenous community members who are accessing your services. And the reason why we say that's a measure of anti-racism, because when I, as an Indigenous patient, walk into a clinical site or a service providing site and I see Indigenous art or territory acknowledgements, that gives me this message that the staff who work here are on a learning journey. There's some commitment here. And to me, it's a sign of potential allyship. Just like when you see the rainbow flag outside of certain office areas or stores or restaurants, when people see that rainbow flag, that's a sign of potential allyship, that this is a safe space for LGBTQ2+. It's the same thing for opening space for Indigenous resurgence. And then the last tool I will offer you is checking out our YouTube channel, just YouTube, Len Pierre Consulting. And you can watch one of our free recorded webinars on anti-racism tools, how to talk about racism with colleagues. If you ever need to give your colleague feedback on discrimination, do you feel like you have the tools to be able to say, hey, I have some feedback for you? I think that the way you handled that back there with that family or that patient or that client was kind of not cool, was kind of not groovy. Do you feel like you have the tools and the language to be able to do that? So, oh, amazing. Thank you, Michelle. It's right there in the webinar chat. Those are the top three resources that I would recommend. Hi, Chika.
Great. Great. Thanks. Thanks so much, Len. So maybe Michelle, over to you. Are there other questions that were submitted?
Yeah, we have three questions that were submitted in advance. I don't see any in the Q&A, but would encourage folks to put their questions in the Q&A. We can get to those if we have time. The first question is, the HPOA also says that regulators need to take anti-discrimination measures, not only registrants or licensees. What is the college doing to do that?
That is a great question. And I am going to ask Kathy Davidson, who is the Executive Director of Strategy, Governance, and Social Accountability, to answer that question because she and her team are very involved in thinking about this from the context of of the college and regulatory processes and operations. So, Kathy, are you able to provide some context in terms of our work around that?
Hmm. That's a great question. What I'll start by, well, I just want to thank Angie and Len for that great presentation. I agree, I'm going to have to go back and read some of the slides, listen to some of the words again. Lots of depth and really great guidance, I think, as we move forward into the HPOA. I'll start answering this question by just mentioning that the journey that health regulators are on started way back in 2017. As a group, we signed the Declaration of Commitment, which was to commit us to embedding cultural safety and cultural humility into our regulatory practices. And so since then, we've all been on a learning journey, and we are recently amalgamated, but the legacy colleges themselves did a lot of work in this area, particularly after the In Plain Sight was released and the release of the Indigenous Cultural Safety and Humility Standard. The HPOA, as Angie very definitively showed us, sort of takes everything to the next level. And beyond what the licensees are required to do in response to anti-discrimination and the guiding principles in the Act, we too, as regulatory colleges, have to do that. So, so over and above what we've been doing over the last 9-10 years, we are now looking at the guiding principles and trying to find ways to embed them into the work that we do, both regulatory process work and governance activities. We are seeking broader expertise on our regulatory statutory committees to make sure that folks on those committees have capacity in cultural safety and discrimination, or lived experience, because that is also valuable to bring on board and to listen to those lived experiences as they're making decisions and considering issues. We are looking, as we have to develop new policies under the HPOA, and as we're doing that, we're sort of going through with a discriminatory lens and making sure that we're considering the language, as Len said, the wording in the policies, making sure that we understand what that language means and how we can implement those policies. So we are looking to revise the policies we currently have and also develop new ones under the HPOA with those lenses firmly in place, and bringing in external consultants if we don't feel we have the lived experience or the expertise to do that ourselves. So it's a slow and steady journey, but we are definitely aware of the changes we need to make in regulation and are working towards them, just as the licensees will be.
Thanks, Kathy. Michelle, is there another question?
Yes, the next question is, there is a cultural safety practice standard, but not an anti-discrimination standard. Will there be one soon?
That's another great question. So yes, we do have we have one cultural safety standard in place, and there definitely has been discussions about developing an anti-discrimination standard. In one of the legacy professions, there was some national standards work done, and I know that other jurisdictions have developed an anti-discrimination standard. So it's work that has happened in other provinces and some professions. So yes, the answer is it is on the list to be developed. We just haven't started that work yet.
Thanks, Diane. And then we have one last question that was submitted in advance. I don't see anything in the Q&A, so still a bit of time if you have a burning question. The last question we received is, how is discrimination different than Indigenous specific racism? We have a practice standard on Indigenous racism. Is this more than what is required in that?
All right, thanks. I think, Len, I'm going to ask if you can add to this. I think you touched on this during your presentation, but you're probably the best person to answer that question.
Yeah, absolutely. Did touch on it. And I think I can answer the first part. How is discrimination different than Indigenous specific racism? I don't think that they are different. They are very much related. They come from the same area, which is colonial socialization, ideology, stereotypes, prejudice. And then when we have discrimination and the harm are both very much two sides of the same coin, I might say. that can happen in varying degrees. Discrimination can happen on varying degrees, as racism can happen in varying degrees as well. So I would say that they're more two sides of the same coin. They are very much the same thing. As for the second part, we have a practice standard on Indigenous racism. Is this more than what is required of that? I can't speak to any college, specifics or legal specifics within the HPOA and anti-discrimination, but I would say that they are very complementary towards one another. And I never really kind of come from this advisory or offering advice that we have to pick one or the other. I'm like, why not both? I think they're very much complementing the work that we're already doing, the work that the college has been doing since before amalgamation, and since before the In Plain Sight report. So I see them as complementary more than opposing or existing in different spaces.
Right, that makes sense. Thanks so much. All right, Michelle, I don't see any other questions in the Q&A.
No other questions.
So maybe we can move on to the last slide and give people a few minutes back in their day. I think we just want to remind the audience that we do have two more HPOA webinars scheduled. So on March 5th, we are hosting a webinar on the complaints, discipline, and support programs work that's underway and changes under the HPOA. And the support programs very much aligns with the conversation today, because support programs will be available for individuals who allege not only sexual impropriety, but also discrimination. So it will be important for licensees to understand a bit more about what that program is all about. And then on March the 18th, we will have a presentation on the harmonized ethical and practice standards, which were developed, went out for consultation, and we received lots of really great feedback. So the team will be providing an update on those standards on March the 18th. And there's a link to the webinar recordings. As I mentioned at the start, this is our fifth webinar, and we hope that they're helpful to licensees as we all prepare for April 1st and the implementation of the HPOA. So thanks everyone for joining. Thanks so much, Angie and Len, for joining us, and Michelle and team for putting this together. And we hope that you have a great day.